So I, on behalf of ACAE and the other organizing organizations, IDTPF, STAR, and Tax Guru, I welcome all of you to the GST certificate course, which we have been doing now for the last, I think, 3 years. I will just, before I start, I will play the ACA theme song. Just a second. Just a second, I'm trying to. Yeah.
निष्काम तू जो कर्म कर, विश्वास हो जो धर्म पर, हर नियति में हो गति, जग जीत ले तू। हो हौसला चट्टान सा, हो श्वास में तूफान सा, मझधार को अब पार कर, जग जीत ले तू। उद्घोष कर, अब हर हृदय में जोश भर, पहचान तू जो लक्ष्य है, जीवन तेरा उत्कर्ष है, जग जीत ले तू। ओ सत्यनिष्ठ तेरी डगर, हो रोशनी हर राह पर, अब बस यही पैगाम दे, सृष्टि नए आयाम ले, जग जीत ले तू, जग जीत ले तू, जग जीत ले तू।
Thank you. I will now request Arun Agarwal ji, convener IDTPF, to please say a few words about this certificate course.
Thank you, Tarun. A very nice ACA theme song which we played. It is really motivating, encouraging for all of us. At least personally, I really felt whenever I hear this, I really feel very motivated. And about this certificate course, as Tarun said already, third year or fourth year, if I remember correctly.
I think fourth year, yeah.
Probably fourth year, if I am not wrong. So fourth year, and this certificate course has actually become very popular. And many times many people ask, अरे अपना certificate course कब हो रहा है, certificate course कब हो रहा है? तो ये जो 10 days का एक certificate course का ये डिजाइन, मतलब ये जो स्कीम बनाया गया है, that is really very nice. Taking a particular theme in mind, ये जो पूरा कोर्स हो रहा है, जैसे this time we are focusing on litigation, so it is going to help a lot to each and every participant. I am sure it is going to add real value to them. So and faculties from all over the country, we are getting faculties, and thanks to Zoom and rather particularly video conferencing, that we are getting this facility, and we are getting faculties from anywhere and everywhere from the country. And today we have our star Gaurav Gupta from Delhi, again representing star and our star as well. So that way, for all 10 days, we will have 10 different faculties from different countries on different parts on different topics. So wish you all the best, each and every participant.
Thank you, Arun Bhaiya. I will now request CA Manmohan Gupta ji, President of STAR, to please say a few words.
Thank you, Taranji. I think Arun Agarwal ji joined only. Sumit ji not joined so far. Good evening, Arun ji. I am happy.
Yes, sir. Good evening.
To see you after a long time. We are happy as a STAR that Association of Corporate Advisors and Executors, Indirect Tax Professional from Kolkata, and Society for Tax Analysis and Research, Delhi, are jointly doing this GST certificate course 2024 on litigation series. Our society is glad to see that our two eminent speakers, Advocate Gaurav Gupta and Advocate Avinash Podar, are guest speakers on this certificate course. Friends, our society always remain keen to do learning program by its own and with other like-minded associations. And we always prefer if we join hands with any organization which are doing learning program. We feel that the topic taken is the need of the hours, or as the time to come is of the litigation in GST. And the government has also set up the tribunals GST. Friends, learning never ends. आपने सबने सुना होगा कि किसी की भी वाइफ कितने हाईली क्वालिफाइड पर्सन को ये कह सकती है कि आपको समझ कब आएगी. So keep on learning. With these words, I convey my best wishes to the success of this certificate course. Thank you and namaskar.
Thank you, sir. Thank you so much for your kind words. I will just request that people who have joined in from multiple devices are requested to please log out from one and just continue from one, because we are facing some technical issues in increasing the limit from 100 because of some payment issues. So we are trying that. Till that time, I will request all of you to please bear with us. Now, with these words, two of our association's presidents could not join because of some preoccupation. Sumit Benani ji from ACAE and Sandeep Kanoi ji from Tax Guru. So they have sought leave of absence. So with these words, we come to the end of the inaugural session. And I thank Arun Agarwal ji and Manmohan Gupta ji for their kind words. I now hand it over to CA Rohit Prasad to take the session forward. Thank you.
Thank you so much. So I am the moderator for the session. Thank you, Tarun sir, for making me the moderator for the session. And today we have one of the esteemed speaker from Delhi, and he's one of the famous speaker across India. So let me introduce you our new speaker, Advocate Gaurav Gupta. Is a graduate from Sri Ram College of Commerce, Delhi University, and a law graduate from Delhi University. He is a fellow member of Indian Institute of Chartered Accountants of India, and he has completed his Masters of Law in 2021 from OP Jindal. He is a practicing advocate in Delhi High Court and tax tribunals. He has more than 18 years of experience in indirect taxation, during which he extensively involved in consulting and litigations. He's not only a person who just deliberates seminars, he also is a co-author of many books and written books of comprehensive analysis of GST on services, goods and services tax laws and practice, handbook on GST and GST manual. He has been a special invitee to the Indirect Tax Committee of ICAI for the financial year 2022-23 and 2012-14, 15, 17, and many years. He has addressed more than 600 seminars on indirect taxes in various forums, seminars, conference, etc. of Indian Institute of Chartered Accountants, Company Secretary. He is also a faculty of GST and Indirect Tax organized by the ICAI GST Commissionerate. Sir, I welcome you for this, and I would like to present our e-memento for today. So this is a small e-memento from all of us. Sir, Gaurav Gupta sir, you can take the webinar forward, and we are ready for your insightful session ahead. Thank you so much.
Thank you, Rohit. Thank you. Respected CA Arun Agarwal ji, my senior, respected CA Manmohan Gupta sir, my dad, President staff, respected Tarun ji, very learned himself and an eminent personality in GST, and he is so humble that he allows us also to take the stage. And I can tell I am very, very keen to have his monthly or I think bi-monthly newsletters which we receive from him. Tarun bhai, they are great value additions to us every time. Thank you, Rohit ji and Shubham bhai, definitely.
Thank you so much.
Shubham
Thank you.
bhai, I think in many of the publications, he has been a great contributor in ICI, and he has also single-handedly contributed to many of them. And par excellence, I find that Shubham ji is one of the biggest name we have today in GST. So I think in this particular fora, among so eminent personalities, I am very, very glad Arun sir, from the very bad times, we have been looking forward to him. And we have been, learning from him since in the, the erstwhile era of indirect taxes. So, sir, please allow me any error or any of the missing which I do today in the session. I would be glad if you can correct me or if you can add value to that. So, Shubham, by looking forward to it. My dear friends, the topic, I think the way it has been chalked out, the way entire sessions have been chalked out, the sequence focuses from the very start of inception of the inquiries, and then they move on to the various aspects, including appeals and writs. The topic interested to me today is basically the inquiry and the SCN, the entire thought process, the key points, the law, what a taxpayer or a professional need to take care or keep in mind during these particular stages, and where are the, I would say, the points where we can address the technical issues which arise during inquiries and the SCNs. We have been facing these particular issues in the recent times. A lot of SCNs hit us for 17, 18, 18, 19, 19, 20 under section 73 in the past 2-3 months. And we are finding that under 74 also. Yesterday, for many of the state, it was the last day to issue SCN for 17, 18. So a lot of professionals are sitting on many SCNs, and everybody is looking forward to how to approach, how to address those particular issues. Many of the assessees, they are fighting, they are wanting to fight on technicals. So we divide the entire approach into factual, technical, legal. Now, where to take up factual, where to take up the technical issues, and where to take up the legal issues. These are the points which we have to keep in mind from the very inception till addressing a SCN. And please also remember, SCN is one stage from inquiry to SCN, where the production of the documents, where the submission of the reply, and most importantly, the seriousness in the representation before the authorities, they decide, they determine the fate of demand. The problem is we approach them in the most casual manner, and once a demand is raised, thereafter we try to make the damage control. That is the portion, or that is the part where much of the water has already flown, and not much can be done at the appellate stages, except the legal issues. So, inquiry, if we speak about, show cause notice can be issued under 16 different sections in GST. However, for raising a demand which is not paid or short paid, or for erroneous availment or wrong availment or utilization of ITC or erroneous refund, the demand can only be raised under 73 and 74. Now, raising a show cause notice is not the first step. Why it is not the first step? And unfortunately, we have found that many of the officers have raised the show cause notice in past directly. So there was some documents which were taken, may be taken, may not be taken. There are details which are available from to them from the GST portal, and using those particular the information, a show cause notice has been raised by the officer. Now, the first question, can a show cause notice be directly raised by a officer, a proper officer? I'm not going into the word proper officer as of now. I'm keeping it for a later part of my discussion. The question is whether a show cause notice can be raised directly without any inquiry, without any intimation to the assessee. My dear friends, the answer lies in the very section itself, because the section starts with the word where it appears to the proper officer. Now, appears is not a one word which is based on notion. Appears is a word which includes a mindful application on certain information where the officer is of the opinion that this particular amount culminates into a demand. So where it appears, now both section 73 and 74, they start with these particular words. Now I take a very simple example, 3B 2A. A difference between GSTR 3B and GSTR 2A. The total input tax credit which is appearing in GSTR 3B of a person is, let's say, 10 lakh rupees. And the total ITC appearing in GSTR 2A is, let us say, 8 lakh rupees. Now, this particular person has 2 lakh rupees of ITC, which is reflecting less in GSTR 2A. The officer looks at the difference, he issues a show cause notice directly. Now, can we say that the officer is of the opinion, by looking at it, can we say, is it correct that where it appears to the proper officer that this ITC has been wrongly availed? Because it's a case of availment. I am availing more than what is lying in my 2A. Can we say so? My dear sir, we cannot say so for the very simple reason. The answer would be in affirmative had we had a seamless system of return. When I say seamless system, as we used to have in the case of VAT, where the information of a particular return is reflected in the tax period of that return of that particular tax period only. And if there was any error, a person need to revise the return of that particular tax period only. In GST, that is not the scenario. In GST, if an error has been committed, if an omission has been committed, the error or omission can be only rectified in the returns of the subsequent period. Meaning thereby, suppose in 17-18, I forgot to take the ITC of 2 lakhs. I took that particular ITC in 18-19. Now, if my officer finds that my ITC in 3B is greater by 2 lakhs compared to 2A, and he arrives at a conclusion that there is a wrongful availment, that particular conclusion is completely incorrect in the factum of this particular law. Had it been the rectification of that particular tax period, yes. So what he has got is not a figure which is relating to a wrongful availment. It is not an opinion. It is an observation. When I say observation, it is an observation which he has made in terms of a difference which is appearing between my 3B and 2A. And when the difference has been noticed by him, the remedy or the procedure which has been provided under the Act is to pinpoint that particular discrepancy to the taxpayer in form of an inquiry under section 61. What is that particular section says? It says the taxpayer, the proper officer may scrutinize the return related to the particulars furnished by a registered person to verify the correctness of the return and inform him of the discrepancies noticed. So the difference between 2A and 3B is not an opinion, but the discrepancy, and this discrepancy finds place or space in section 61. So he could have done an inquiry under 61, issued me a ASMT 10, which should be replied by the taxpayer in ASMT 11, and thereafter he is open to either pass the order in ASMT 12 or he can issue the show cause notice. Similarly, the audit is another mechanism. So after 61, the officer has power under 65. What is the power? The officer can be authorized by commissioner to undertake audit of the registered person at such frequency and manner as may be prescribed. Now, whose audit should be made? The audit is again the selection of the SSC is a very scientifically driven mechanism which is made by the system, which is made by the GSTN on the basis of some risk parameters which may vary from year on year selected by the authorities, and the assessees are selected thereon. So for example, any assessee who has used more than 95% or 96% of ITC for payment of output, those particular cases may be taken up for audit. Any assessee who has multi-location within a particular state, he may be taken up. Any SSC which has a growth of turnover by more than 300%, that particular SSC may be taken up. Any SSC which has input tax credit, which is a culminating or accumulating amount of more than 10% of the total ITC of that particular year, he may be chosen. So those particular audit criterias are very scientific criterias, and on the basis of their experience, they are open to take up. And then the officer may require the registered person under that audit, under 65, to produce the books of accounts so that he can verify, and also require him to furnish the information which he require or render assistance for the completion of the audit. Now, what is audit? Audit again has been defined in section 2. Section 2 very finely defines audit, and it is not choosing any ad hoc word. Audit is very confined, very specific. Audit means examination of records, returns, and other documents. So whereby the examination power of the officer is not limited to the returns or records which are prescribed, but it can also include other documents maintained or furnished by the registered person under GST Act or under any other law in force. So your labor register maintained for ESI is also a record which can be examined by the officer during audit. But the most important thing, can he ad hocly look into any kind of record? Sir, he may, but then that particular examination should be to verify the correctness of the turnover declared, taxes paid, refund claim, and ITC await. In 4 aspects, the verification can happen. And if he is not related to these particular 4 examination, then he is not into the scope of audit. He is actually going beyond the scope of audit. So this is the second power given for examination to the officer after 65. Apparent, then on the basis of risk criteria, he selects the SSC, conducts the audit. Special audit. If the officers not below the rank of assistant commissioner, he is of the opinion that having regard to the nature and complexity of the case of the assessee's business or assessee's compliance and the interest of revenue, so he has also to see that there is some substantial revenue which is included in that. So if the total ITC of let's say the total output of a person who is a cobbler and very complicated kind of input output he has, total amount of tax involved is, let's say, 2 lakh. Now the amount does not satisfy the interest of revenue, and therefore one can challenge that this is not a special or a fit case for special audit. Special audit is an extraordinary scenario where you are actually putting the assessee to a special investigation. I would say investigation may be a tougher word, but to a special checking, and therefore it cannot be put into normal circumstances. Only in very, very rare circumstances, a special audit can be called for. And what are those circumstances? Which is regarding the nature and complexity of the case and having the interest of the revenue. The opinion which the AC should form AC or any officer, higher in rank, that the value has not been correctly declared or the credit is not within the normal limits. So there has to be some level of opinion which he has to form before assigning a special audit. And then with the prior approval of commissioner, we can direct such particular person to get his books of accounts examined and audited by a chartered accountant or a cost accountant, which is nominated by the commissioner. So a special audit cannot be undertaken in normal circumstances, but in the circumstances which are put into the section, and the courts have very, in past also have examined the requirement of special audit, which is in very, very specific cases. The observation of the courts have been that the law, which has been codified by the parliament, is very, very determinative of the circumstances in which these particular exercise can be undertaken. Now, in case of a special audit, it is only a very specific opinion, which is when so formed looking into the complexity and the nature of the business, that this particular an SSC can be subjected to a special audit by a chartered accountant, not in any other normal circumstances. So they have, the courts have held that these are not normal exercises, while audit is a normal exercise. So the first one was a very, very simple exercise, ASMT 10, which is merely a discrepancy notice can be informed or intimated to the SSC. Second, a thorough check of the compliances made by the SSC to verify the 4 aspects, which is by way of audit. Third, section 66, special audit where he is put to test under various circumstances. And then comes the most troubling section, which many of the SSCs and the professionals, they find that this is also to be used in a very rare circumstance. But in the past 4 years, starting with 2019, end of 2019, many of us have seen that power of inspection, search and seizure has been invoked in multiple cases by the department. Now, my dear friends, you have to remember those were not normal times. Why they were not normal time? At the advent of GST, there was a whole battery of registered persons. I'm not saying taxpayers. A whole battery of registered persons who came up, and where it was found that those were non-existing taxpayers. Or for that matter, even if they were existing, they were persons who were never paying the taxes. So they were those which we know very commonly as fake or bogus dealer. Terms are not defined in the statute, but they have been fondly called as fake, bogus, non-existing dealers in multiple states and different names. Because of that, a lot of chain of buyers and suppliers were put under scrutiny, and where power of inspection, search and seizure under section 67 was evoked. This is also very specific power, and it can be used only in extraordinary circumstances, which have been provided in section 67 subsection 1. And only an officer not below the rank of JC can order for such an action, where he has a reason to believe that the taxable person has suppressed any transaction relating to supply of goods or services, or has claimed input tax credit excess of his entitlement, or has indulged in contravention of any provision of the Act. In these 3 specific circumstances, and most of the cases where 67 has happened, is the second one where it has been put to test whether he has claimed the input tax in excess of his entitlement. So when you are handling one chain of bogus transaction and you are having that this particular person is not having any ITC, he has passed on the ITC to the other person. The first inspection happens on that particular person. If he is found to be non-existing, then all his buyers are again put to inspection, search and seizure in one mode or the other. It can be in the form of a summon. It can be in form of a search at his premises. So this will depend. This will depend from the gravity, from the the quantum of taxes involved, and also again the involvement of such particular person in the entire chain of transaction. So last 4 years have been much happening under 67. Not many notices of 65 has been seen, but yes, many notices under 61 ASMT 10 were duly received, answered by the assessees. After 67, another power, and which is a very mild power, of visit to the business premises for scrutiny verification checks to safeguard the interest of revenue. A visit may be made. It is not search and seizure, but a visit to intimate that there is something which need to be checked, and the officer can call for the records and shall allow a 15 days time to produce those particular records to the taxpayer. Having enforced or having used these powers 61, 65, 66, 67, 71, having in possession the requisite information, and after taking suitable clarifications from the existing taxpayer, then if the officer is of the opinion, then if it appears to them that there is some short pay tax or wrongful availment or utilization of ITC, that is where the show cause notice gets into place. Then it is a proper show cause notice. It is a show cause notice which is not based on surmises. It is based on a proper inquiry with full information, having the replies or the submissions from the taxpayer, and thereafter, on the basis of all the submissions, an opinion has been formed of short payment and not mere discrepancy. So the first thing which I'm wanting to park in everybody's mind, the show cause notices which have been issued without inquiry, they are not valid show cause notices. Another question which might come up from many of my learned friends, is the requirement to issue DRC 01A necessary before issuance of DRC 01? Now, what is that, sir? It is basically a pre-intimation that department wants to raise a particular show cause notice of a particular amount of demand, which is informed to the taxpayer for him to comply. Now, this pre-intimation earlier was a mandatory provision where the word which was used was shall. Now, this particular word shall has been replaced by the word may. This was replaced by the word may, and now this particular issuance of DRC 01A has been made rather than mandatory, it has been made at the discretion of the officer. But will it mean that it is the choice of the officer whether to issue this particular form or not? In my humble opinion, the word which has been substituted from shall to may was out of the understanding that in those cases where the amount is already communicated to the taxpayer, what are those cases? So, for example, there is an audit which has taken place. In that particular case, the assessee is already intimated that this is the audit observations, and he has to put up his own paras in terms of agreement and disagreement on those particular paragraphs. So he may accept, he may deny. So he is fully aware that these particular demands are likely to be raised against him. In those particular cases, I am of the view that officer may not issue the DRC 01A because he has already complied by way of the audit note of the intimation. Similar fate will be in case of ASMT 10, where the discrepancy has already been informed, where the reply has been taken, and if he is not satisfied, he is proceeding for show cause notice. So in those particular cases, this will not be optional issuance to the officer. But in any other case, where there is no ASMT 10, where there is no intimation, where there was no search conducted and intimation in terms of any specific parties or specific information has been shared, in those particular cases, issuance of a DRC 01A is a mandatory. That may should be read as shall, because there is a action which is being contemplated against an SSC, and that particular action should precede an intimate information to him. You are not giving a surprise to the officer, to the SSC. Issuance of a show cause notice is not a surprise to the SSC. It is a thoughtful exercise, and the gravity of raising demand against anyone is very much a serious concern for such particular person, and therefore this particular exercise should be undertaken in the manner as may be provided under the provisions of the law. The process should be followed to each and every and the last letter of the law. So my dear friends, any DRC 01, the show cause notice, which is issued without any prior intimation. So first stage was inquiry. Second stage is intimation. Third stage. So 2 points I've discussed. Third stage. Inquiry undertaken, intimation given. Still, will it be the show cause notice will be valid? Before I go to that, there are 2 more points which you need to keep in mind. Number 1, at the time of any initiation of the inquiry, the word which has been used in all the sections is proper officer. Proper officer, in very simple terms, if I have to put it, he is your jurisdictional officer. He is the officer who has been entrusted the jurisdiction of a particular taxpayer. Both center and state, they have their own jurisdictional officer in respect of every taxpayer. But as a matter of policy, I will not say law, because law does not bind which one is your proper officer. As a matter of policy decided in GST Council and agreed to, the proper officer in relation to any taxpayer has been agreed, and the jurisdiction of each SSC in the country is entrusted either to center or the state. So in normal course, the proper officer will be the officer, jurisdictional officer of that particular state or center to whom the SSC has been entrusted. While defining the definition of proper officer, section 91, it simply say in relation to any function to be performed under the act, it means the tax officer who has been assigned with that particular function. And the function has been assigned by way of circular number 3/3/2017 under the Central Act, and by the various state notifications has been issued, SROs or state notification has been issued by the various state. Now the proper officer, if we look into section 73, it is a single word and it does not refer to multiple people. So a proper officer should be one officer who has been assigned that particular function. Now, who will be the person who is assigned that particular function? That person who, number 1, has a jurisdictional control over the SSC. Number 2, who has been entrusted the function of section 73 under the circular or the notification of respective state. And number 3, who in terms of the jurisdiction defined between center and state is the person whom the SSC is entrusted. So when these 3 things are fulfilled by a particular officer, then he becomes the proper officer. In my humble opinion, it will only be the jurisdictional officer to whom the SSC has been defined. Now we find that there are multiple investigating bodies, there are multiple audit bodies who undertake various functions. That particular person can, those particular bodies or sub-departments of the revenue, can they issue show cause? In my humble opinion, the matter is right now sub judice. While the power to investigate by DGGI or anti-evasion, or for that matter, the state enforcement, even in cases where the SSC is not under their jurisdiction as per the division between state and center, still the investigating power, as has been agreed in 3 GST Council meetings, can be undertaken by anyone. But to very surprise, none of the GST Council meetings have agreed to have a different proper officer in case of such assessment. So while the investigations have been shifted or has been allowed by multiple agencies on different aspects, now on the same aspect, one agency which has initiated will take it to its logical conclusion. Very clearly in the circular, they have clarified that. Rather, letter they have clarified that. But on different issues, different agencies can undertake. Even Honorable High Courts have said that parallel audit and investigation by DGI, audit by the department and investigation can be undertaken. Investigation by multiple agencies, parallel audit and investigation, these are different aspects. But after the investigation, after the audit, the report should be submitted to the jurisdictional officer, who will then form an opinion from the investigating report whether this particular tax is short paid, not paid, or a tax or a ITC has been wrongly availed or utilized. And thereafter, the proper officer, who is your jurisdictional officer, can issue a show cause notice. So the liberty to issue show cause notice, in my humble opinion, does not lie or vest with multiple agencies. The term which has been used is proper officer, officer which is entrusted with that particular work. And that particular officer need to satisfy all the 3 conditions to become the proper officer who is capable to issue such show cause notice. And it is a very serious exercise. Why I am saying so, sir? So there was one investigation undertaken by anti-evasion, one by DGGI. Now they are in possession of the data. Now sitting on the data which has been received from the taxpayer on the 2 days before the last date of issuance of show cause notice, both investigation and anti-evasion found that there is one party which is a suspicious supplier, and both of them are issuing show cause notice. So if there is not one proper officer, there will be multiplicity, overlapping, there will be multiple demands on the same issue, and the assessee, taxpayer, cannot be held responsible to address multiple show cause notices on the same issue, same year, before different authorities. That is not the spirit with which, when it is decided, one taxpayer, one assessing officer. So one assessee, one assessing officer. The spirit has to be followed. While investigations cannot be, or they are not put to check, the show cause notice has definitely been put to check by not expending by the GST Council to various officers. So please do keep this in mind. Number 1, proper inquiry. From the inquiry, the formation of the opinion. From the opinion, intimation of that particular opinion by any manner. And if no manner, then DRC 01A to the taxpayer. And thereafter, in the form of a proper show cause notice. That is the spirit of the law in which this particular show cause notice should result. Otherwise, it is a mindless exercise. And it cannot be that you are holding someone responsible for payment of a particular amount on a very non-serious mode. So you were very casual in raising a demand of 10 crore, again an assessee. Sir, it is a very serious and disturbing event. A show cause is a very serious and disturbing event for any taxpayer. Any person who gets a show cause of 3 crore, 4 crore, 2 crore, he is not able to get a proper sleep for the very simple reason this particular person is sitting on a demand. If it is not properly addressed, it will culminate into tomorrow the recovery. There is a show cause notice which is not addressed, culminates into demand, not preferred in appeal. And sir, the gravity has to be understood from the very fact. Any appeal which is to be preferred, I'm not taking up the appeal, I'm just putting a small thought, connecting it to show cause notice. Any appeal which is to be preferred requires a pre-deposit of 10% at the first appellate stage. and another 10% now, which is reduced. Earlier it was 20%. At the second appellate stage, at the tribunal stage. Now, my dear sir, if there is a 10 crore demand, which is based on surmises, it pushes the person to deposit 1 crore at the first stage and another 1 crore at the second stage. How troublesome it may be for a taxpayer who might not be in a position to gather that particular amount. And those particular circumstances, a person is left with no choice. And in very, very rare circumstances, extraordinarily rare circumstances, the high courts might intervene if it is in the interest of justice. So, but that will be rarest of the rare case, I'm telling you. And they will also not be setting that as a precedent. So the honorable high courts, it will be very tough for any person to approach to waive off. But yes, extraordinary circumstances one can approach. So, sir, one process or the clarity when you are addressing any show cause notice. So from the very inception of the inquiry, how it was undertaken, what is the submissions made at that point, what are the points raised by the officer at that point, how were they addressed, and then how the officer made that opinion. Thereafter, you reach the show cause notice, and then you see a lot of things. But inquiry, at the stage of inquiry, I'm going a little back again. We all understand inquiry can be under 61 ASMT 10 or 65, 66, 67, 71. Let me take the case of 67. Whenever the inquiry is undertaken, we only look at the summon and we only know that we only have to check what din. If it is a din, it is a valid summon. We know it. If it does not have a din, what we have to do with that summon, we don't have to comply. That is the statement we have received from the Honorable FM. And it is a very good check. It is a very strong check. I think the revenue has controlled the inquiries which were not on records by putting that particular din. So it's a very mindful action. It's a very controllable action by the revenue. And they were aware that by putting the din, the inquiry will only be the inquiry which is a formal inquiry. Now you know there is a summon which has a valid din. Din you can verify from CBIC website. It will give you the initials, an idea what is issued, who is issued, to whom it is issued. Having said that, merely a summon, will it culminate into a proper inquiry? No, sir. Who has issued the summon? Whether that particular person, does he have a jurisdiction over the assessee, the taxpayer? That is very, very important to see. When you participate in any inquiry, you have to be mindful of the fact that the inquiry should be, from a proper officer having a jurisdiction. Section 70, summon is different from an inquiry. Summon can be issued to any person who is in possession of the information which is important to that particular case. So the proper officer can summon any person who he considers he is required to either give evidence or produce a document or any other thing in any inquiry. So he may not be an accused. He may be a witness. He may be a person from whom he wants to know any information. So from the inquiry is going from the supplier, but from the buyer, the officer wishes to understand. So in every summon, you will find that there is a very clear mention that in respect of which case, who is the person being summoned, where is he being summoned, at what time is he supposed to be produced, before which officer, and what does he need to, what is the agenda of that particular summon. So he need to produce any document or he need to render a statement. What is the agenda should be very clearly mentioned in that particular summon. If either of the components are missing, it will be a invalid summon. Now, jurisdiction, summon, inquiry letters. Having done so, I am coming on because paucity of time. I'll take another half an hour, 40 minutes, because I will also take up the queries from my learned friends who are listening. So we will also share some very interactive 20-25 minutes, the questions also and the views also, because every view adds value to everyone. That is my humble belief. So show cause notice after proper inquiry by proper officer culminated on the basis of proper information. Now you have received show cause notice. Many of us believe, अरे अब तो show cause आ गया, अब तो demand पक्की है. Sorry, sir. Show cause notice has a very pious function. It has its own sanctity. What is the function of a show cause? It is on a very serious note. It gives an opportunity to the taxpayer that before I confirm a particular demand, I am of the view, the officer is of the view that this particular demand, on the basis of these particular information and allegation. Now, please understand, appreciate, on the basis of certain information, it has to be factual, and then there has to be a allegation. The officer wants to confirm a demand against you. So when you say about show cause, there are 4 very, very important things which every show cause must have. NASIN, the premium body of government training, it has said that 4 C's are must in a show cause notice. C. First C. Who is the person charged? The charged person. If the show cause is addressed to a wrong person, it will do away. The allegations won't stand. More importantly, today the show cause notice is required to be issued on the portal of the taxpayer. Earlier, in the case of Shyam Baba Edible Oil, Honorable Madhya Pradesh High Court held that the show cause, though there are 7 different ways under section 169, the show cause can be served on the taxpayer. Out of those particular options, the legislature then reduced the option of the proper officer as how to serve the show cause notice. The only mechanism which was chosen by the legislature was by uploading on the electronic portal, which is your GSTN portal. So if it is not uploaded on your portal, that particular show cause notice is not a valid show cause notice, because its service is not proper and not in the manner which is provided under the law. So the choice which has been made by the rules in terms of serving the show cause notice was limited to the uploading on the common portal electronically. Rule 142, sub-rule 2, it very, very clearly says it has to be made available to the person through common portal electronically. Right, sir? Now, the word electronically has been chosen, but electronically, this is not possible in any other manner other than this one, common portal, because we don't have any other mechanism. Yes, it can be done through email. Maybe, let's examine, let's tomorrow see. But if it is given by speed post or for that matter by hand, those are not the options which has been provided. And more particularly, the instructions which has been given by the department by instruction number 4 by 2023, it has been clarified that proper officer can only, they were directed that the serving of the notice in DRC 01 should be made electronically on the portal. So even if we say that there was a small doubt in terms of electronically, it was ironed out in terms of the instructions number 4 by 2023. And it was very specifically mentioned in the instruction that non-issuance of such particular orders or notices, so not even notices, even the orders have to be electronically on the portal, is in clear violation of the explicit provisions of CGST rules. And therefore, it will not only make the said notices infructuous, but the entire proceedings void. So if you have received any such notice which has been not served on the portal, you can make your preliminary objection that this particular notice is not served in the proper manner and therefore is not required to be addressed, and more particularly because of instruction number 4/2023. So the first thing is charged person, 4Cs we were talking about. And while I was speaking of this electronic issuance, the person SCN should be on the correct person. So I give you a very small example. There is a person who is the proprietor of Sai. It's a fictitious name, Sai Electronics. And he also has a private limited, Sai Electronics Private Limited. Now the SCN was supposed to be issued to Sai Electronics Private Limited, but it was issued to Sai Electronics on his GSTN. And tomorrow the officer says, sir, it was inadvertently issued on Sai Electronics. Sir, no. The charged person should be correct. You cannot raise a demand of one person on another. Proprietor of a firm and director, being a director in another company, and when you are wanting to charge the company, it cannot be issued to the proprietor. So if the first C should be charged person, which should be very, very clear. Second, what is the contravention? What is the law which that particular person has contravened? So there has to be some information, inquiry, observation of that particular inquiry, and then you have to tell this is the legal provision which has been contravened. Then that contravention, what are the consequences? Third C, consequences. And last, the charging paragraph. You have to put that particular person to show cause notice on very specific points that these are the charges which I am making against you. Charged person, contravention, consequences, and the charging paragraph. 4 C's are must for a valid show cause notice. Either of them missing, show cause notice is not valid. Right, sir? I hope this one particular point, which was very, very important, is very, very clear. Now, when you say on the other aspects of show cause notice, jurisdiction, I will not repeat. I will not repeat. My dear friends, just 1 second. I'll take 1 minute. My humble apologies. Friends, the last C was the framing of the charging section, charging paragraph, sorry. So the charges have to be spelled very clearly. So if the even though you have spoken about the contravention, you have spoken about section 75 interest, but you have forgot to put that particular charge in the charging paragraph. So then that particular charge need not be replied by the taxpayer, and therefore that will not be culminating into a demand tomorrow. So what are the section in terms of penalty? What are the sections under which demand has been raised? So can a demand of output be raised under 16? No, sir. So the officer need to put in the contravention very clearly. So when we say, that the officer has framed an opinion, has made an opinion, it is the end, sir, the demands are going to be raised. Sir, no, sir. The only thing which we approach the show cause notice is with the mindset of a scrutiny. That is the whole problem. Under income tax, 148 is entirely different from what 73 and 74 under GST are. 148, it begins with a show cause notice, which is equivalent in terms of approach with 73 and 74. But once they cross the stage of 148A and the inquiry enters into 148, read with 147, 143, it is a proper inquiry by the officer. It's a proper scrutiny. While under 73-74, the scrutiny is over. The charges are framed. It is the very specific points which you have to address. What is the contravention? It is specific. What is the amount of contravention? It is specific. Can the amount of contravention not specified? No, sir. It has to be specified. Some of your ITCs are not proper. You are hereby requested to kindly bring records in respect of such ITC. Is it a valid show cause notice? No, sir. In my humble opinion, merely a difference of 2A, 2B, 2A, 3B, sorry, is also not a valid show cause notice, because where it appears to the proper officer, that is the language which is written, where it appears to the proper officer that, now please understand, I'm talking only in respect of ITC. I'm right now not talking about the output. Where it appears to the proper officer that input tax credit has been wrongly availed. Now my question is, sir, which input tax credit? I have taken 1000 line items of input tax credit, and maybe out of them there are some extra. But when you are raising an allegation, you have to be very, very clear which line items. And if that is not the case, you have got the power. You have got the power. The proper officer has got the power to make a best judgment assessment also. Now that is also in very, very specific cases. So that opinion, either it has to be based on a real factual situation, or it has to be based on a best judgment. But it cannot be so that that particular opinion does not have a base. The missing or the gap need to have proper line items. So in my humble opinion, the only a quantum in the show cause notice leaves the assessee as a victim to choose the allegation himself. Sir, which line item should I choose to answer? I have 1000 line items. 2 lakh can be a total of 300 line items also, or maybe 4 high value line items also. Which is the item which is being spoken, sir, which is not appearing in 2A? Now that is the question. Now I add to the complexity of the case. Sir, not appearing in 2A, under what provision has the contravention specified in the show cause? No, sir. Since the contravention is not specified in the show cause, because there is no provision which says that if it is not in 2A, it will not be allowed. It is only in 2022 that 16(2)AA was introduced, whereby it was mandatory that reflection should come. And if it is not there, then your ITC will be disallowed. In that particular scenario, sir, the situation is very, very clear. Contravention should be, number one, quantified, number two, with basis. If it is not with basis, now coming on to the different scenario of show cause notice. DGGI issuing show cause notice to 400 people, 1000 people, 130 people, all being part of one particular chain of investigation. Is it permissible under law? Is there a common portal which allows the issuance of one show cause notice to multiple parties? Sir, no. The entire act, rules and the infrastructure or the GSTN has been so framed, requiring the investigation to show cause notice being pursued in respect of each person specifically. Is it possible that those 300 persons, they come out with a single reply to the department, and then let department also sit on that particular reply, looking on which reply portion relates to which assessee? So, sir, similarly, the assessee can also not be put into that particular scenario where he becomes a person who, out of those 400 pages, is required to choose his own facts. Number one, the first important part of the show cause notice. Number two, the part of investigation which is relatable to him. Let him choose. Officer thinks that the statement of the supplier is very important, or for that matter, supplier is very important. But the assessee who has chosen says, no, this statement is not important for me to reply. Now, sir, there is a difference. The difference is on account of understanding from a common show cause notice. Therefore, the show cause notice need to be specific that if any statement, any fact, any panchnama, any relied upon document, any fact in that particular show cause notice, any contravention is there, it should relate specifically to the person to whom the show cause notice is issued. The person cannot be subjected to be left to the mercy. Brindaban Beverages, Honorable Supreme Court, it is the foundation of the entire proceedings. If the foundation is vague, if the show cause notice is vague, it is liable to be quashed. Tried law. No ambiguity should be there in show cause notice. The Honorable Supreme Court has from time and again has very clearly laid down that no vagueness, no ambiguity should be there in SCN. If a SCN is vague, if it is arbitrary, if it is fanciful, it is not but illegal, irregular, and liable to be quashed. Any ambiguity and vagueness will make a show cause notice void, illegal, and not to be pursued. Now, having understood these particular points, some of the scenarios also, there are certain important aspects which we also need to keep in mind. Show cause notice is the foundation of any adjudication. It can only be issued after proper inquiry. It has to be in writing, unambiguous. It has to be intimating the demand, interest, or the penalty which is to be demanded. It has to be in the proper communication mode and served in the manner as provided. These things we have discussed. 4 C's I have already spoken about. The NASIN has also gone ahead in terms of putting a clear checklist of what is to be given in those particular show cause notice. I'm not going into that. I am skipping that particular part because now the most important part. When you are addressing show cause notice, what should be our approach? Sir, 73 is over. 74 is now over for some of the states yesterday, and some of them will become time barred tomorrow for 17-18. The very fine differential between 73 and 74 is the selection of the cases by the department on the basis of 3 scenarios, which is fraud, willful misstatement, or suppression. Unless either of the elements are present with the intent to evade the tax, the larger period of limitation cannot be evoked. So for 73 show cause notice, none of the 3 elements are required. A simple show cause notice of demand based on the observation of the officer, ample. But this has been over for 17-18, 18-19, 19-20. A show cause notice under 74 can only be raised when the department can clearly establish either of the 3 elements on the part of the taxpayer. And there is also very important a part that this particular allegation of fraud, suppression, willful misstatement in those multiple assessee show cause notice has to be established very clearly against each of them. If it is missing, that particular person cannot be served with the show cause notice under section 74. So demands for 17-18, 18-19, 19-20 can only be set aside by the quasi-judicial authority, or for that matter, the courts, on the basis of limitation. I hope I'm very clear, my dear friends, on this particular part. So in terms of extended period, one has to be very, very clearly, if a 2A, 3B difference is there, 2A, 3B difference, can it be raised under 74? No, sir. First of all, I had my reservation on this particular difference, but more importantly, 2A, 3B was always available. It is not something which is taken out, dug out by the department. It was not found after any inquiry. It was apparent on my portal. So 2A, 3B cannot be under 74. 74 needs a specific allegation of fraud, willful misstatement, or suppression. It cannot be on the basis Gannon Dunkley and Company Limited, Delhi Tribunal decision. Very simply, we can understand that when the information is from the return and the returns were already available with the department, the same cannot become a position under the extended period. It is something which is already available with you. So anything which is there in the returns, any apparent differences, 1 versus 3B, 2A versus 3B, they can never be a matter under 74. One can very easily contest these particular thing. Now, having said so, having understood the limitation part also, the show cause notice, one has to be, let me put it in another. The first onus, I'll start with section 155 because show cause notice on ITC is very, very important a part. 155 section, as we all know, is being quoted all across by the authorities, though ITC is being dealt under section 16, 17, 18. But this one section was very surprisingly kept at a very later part where it was speaking about the burden of proof in case of input tax credit. It said where any person claims that he is eligible for input tax credit under this act, the burden of proving such claim shall lie on such person. The burden of proving such claim shall lie on such person. The person can only prove a claim, number one, by way when he is being called upon to prove that burden. So I cannot go to the department if I filed my return taking all my invoices. Sir, these are the invoices basis which I have taken my ITC, and therefore see under section 155 I am discharging my burden of proof. Is this the intent of 155? No, sir. Which leaves us with the only option. The section means that one needs to prove the burden when being called upon. So, number one. Number two, I have filed my returns under 155. Now, these are the various positions which we have taken in various cases, and therefore being all matters being sub judice as of now. It is the time, my dear friends, to actually think to address the issues in a innovative manner, to address these particular gravities, because what we approach, I again reiterate, is in a very in a manner where we think it is a mere scrutiny going on. No, sir, it is not a scrutiny going on. Now the allegations are framed, and you only have to keep yourself reserved to those particular allegations. You have to restrict yourself to those particular points only. So when the person under 155 is being called upon to prove that he has taken a eligible input tax credit, that person produces the required. What is the requirement? Under section 16, subsection 1, the first requirement, it should be in the course of furtherance of the business that he has procured those goods or services to which such input tax credit relates. Number one. Number two, under 16.2, he is not falling in either of the restrictions A, B, C, D. He is possessing a valid tax invoice. He is in receipt of goods or services. The supplier has paid the tax. Let's park 16.2C separately. 16.2D, he has filed his return under section 39. Then the barrier in terms of depreciation under 16.3 and timeline under 16.4, which has been again relaxed by the government and the previous GST council meeting. Now the only discussion leaves around is 16(2)(c). Sir, there was an impossibility. I never had any option but to check only in 2A whether the tax has been admitted by the tax supplier or not. And if it is appearing in 2A, that admission of such supply and the payment of tax is made by the supplier. And I have made the payment of tax to the supplier. I need to prove that. And applying the ratio of corporation bank decision, where it has been held that the person collecting the tax is an agent of the government because he has been so authorized under the law and given due registration for collection of such particular tax by the government. The payment to such particular person discharges the onus of the buyer or the person required to pay the tax that he has paid that particular tax to the government. So impossibility plus paying it to the agent of the government, I am discharged by 16(2)(c), and when he admits in 2A, that adds on to my claim. So that is how I have now discharged my onus under 155. If now the officer is not satisfied, he cannot evoke 155 now. Now he has to come out with very clear allegation as to why and under what 16A, B, 2A, B, C, D. Under which of the provision is he challenging the eligibility of input tax credit? If he does not provide so, then in that particular case, the show cause notice is not a valid show cause notice. I hope I'm very, very clear, my dear friends. Traveling from 155, the relevance of 155 vis-a-vis 73 and the approach. So in case of 16(2), as you already have, looked into, but Honorable Supreme Court, again, in the case of Ecom Gill Coffee Trading Company, it was upheld, it was held by the Apex Court that the onus is on the buyer to prove that he has made so purchases. Mere production of the invoices will not discharge his liability. If you have made purchases, you are required to prove that yes, those particular purchases came to you. Now, in what manner, that is your choice. But yes, you can't just give a simple statement. There has to be some logical reasoning. Now, if you are a trader in metal, which is transported in trucks, maybe a dharam kata or a weighbridge slip, because you can't weigh 10 tons of metal only by looking at it, only by looking at the truck. So what logical method you use to weigh that particular, and that will prove your receipt of goods. Your GR is a very strong proof. Your serial number of electronic goods is a very strong proof. Any single proof you need to put in to establish that goods were received, and there has to be then a counter. There has to be an allegation to counter your claim in the show cause notice. If it is not there, then you are discharged from your own burden and there is no valid allegations against you. Recently also, if the officer has not seen, many decisions have remanded back the cases to such officer to look into the documents produced by the assessee, LGW, Gargo Traders, and number of them are there. So in those particular cases, it has been held that those particular documents need to be examined before disallowing any eligible ITC. Cancellation of supplier, Engineering Tool Corporation, Madras High Court. Input tax credit availed by assessee was reversed merely on the cancellation. It was held that the assessment order need to be quashed. It is not one of the conditions. Retrospective, sir, again, retrospective is also not one of the cases where eligible ITC can be, because retrospective means at the time when the supply was made, it was a valid registration. Again, in the case of TVL Cleon Optobiz Private Limited, again, Madras High Court. Non-declaration in GSTR 3B. Very, very interesting case. Assessee claimed that the input tax credit, which is stated in 2A and in 9, were duly properly reflected, but it forgot to declare that in 3B. So it was remanded back. The order was held to be invalid. In the case of Shanmuga Hardware Electricals. So my dear friends, that is again Madras High Court. So I think in case of ITC, you can look for decisions from Honorable Madras High Courts. It has taken a very balanced kind of a view towards the SSC. The Honorable High Court, I would say, has come to the rescue of the taxpayers, believing in taxpayers. Mind my words. The Honorable High Court has placed huge reliance in the taxpayers coming before it and has granted relief. South Engineering Services, again, inadvertent error, but correctly reported in 3B, matter remanded for reconsideration. In all these particular cases, the matters were tried to be put to a particular logical end where there was a non-examination from the assessing officer. Very surprisingly, two circulars, 183 and 193, were issued by the department. 183 for 17-18, and then there was a future application because of the Wipro decision. It was again extended to the future years, but 193 came in a very restrictive way for 17-18, 18-19, 183, and thereafter 193 circular is applicable. What it required was, if it is not coming in 2A, one of the credits, then you need to produce the certificate of the supplier to substantiate your claim. Now, my dear sir, when the show cause notice merely tells me that there is a difference of 2 lakh, which supplier's certificate should I bring it to you? There is no allegation. Number one. Number two, where in the law is the matching with 2A required? So how can a circular go beyond the provision of law? Will it be a valid circular? Again, the wires are to be challenged. The law first speak out that there is a requirement, and then circular may lead the provide the guidelines. When law itself does not have any provision of comparison of 2A and 3B for 17, 18, 18, 19, how can the circular make it mandatory to get these certificates? More importantly, you may be at good terms with some of the supplier in 17, 18. He is a regular filer. He forgot or he inadvertently reported one of your supplies in 3B. Sorry, B2C. My humble apologies. Today, you are not on speaking terms. That is one case. The company has amalgamated, another case. The proprietor is dead, another case. The company is into NCLT, another case. The person has closed business, moved to another city, another case. You are not in contact with that particular person, another case. How in all those particular circumstances, you can obtain a certificate from that particular person? And let it be, the person does not have the time to issue your certificate. Forget it. The person is there, the person is available, he does not want to issue your certificate. What can you do about it? Sir, if it was a requirement, that certification could have been made a part on the invoice itself, as was done in the case of excise. Why this so-called after 6 years post facto requirement came into picture? These are some very important points, which one should address at the time of answering the show cause notice. So please do not merely go and prove. Yes, merits, you should be strong. But yes, apart from merits, please raise the contentions that there are other important issues which were ignored by the proper officer while raising the show cause notice. A vague, ambiguous, casual, predetermined, based on surmises, any category of these of show cause notices are liable to be quashed. One very important decision, non-reflection in 2A, Diya Agencies versus State of Kerala. The Honorable Court held, while remanding the matter back to the officer, if it was said that if on examination of the evidence submitted, the assessing officer is satisfied that the claim is bona fide and genuine, the petitioner should be given ITC. Merely on the ground that it is not reflected in 2A should not be a sufficient ground to deny the claim of ITC. Now, because of these kinds of decisions, the circulars were issued by the department or by the revenue. Those cannot sort of take away the spirit in which the law was there in 1780. Any certifications which were required should have been informed at the time of purchase. It should be known. It cannot become a post facto event for collection of documents for 6 years back event. I think for any bona fide taxpayer, these will come to their rescue. So there are a number of decisions which I can speak on. I would love to take up 17.5. Yes, there is a lot to speak, but I think with the paucity of time, I'm left with another 20 minutes. So what I'll now save is the question answer time. I mean, if Rohit ji is there and Tarun ji is there with their kind permission, I would now like to take up the questions of the friends who are there with us. Friends, in your chat box, if I think you will accord me the permission to take the questions, or if any specific thing is there, you let me know. I was not able to look at the chat box till now. Now we'll be looking at. Tarunji.
Yes, thank you, Gaurav ji, for your wonderful deliberation. So you can maybe just go through the chat box and you can answer these questions one by one.
So I am taking it from the very inception.
Yes. Okay.
Yes, sir.
I think the first one was section which you were referring to. Please highlight. I am sorry, but I cannot relate it at this point. So I'm moving further. Scrutiny or complication as finance, healthcare, or technology. Sesadri ji, I think this is very sector specific. Let this be. We will take up some sector specific discussion later. Can DGGI initiate someone based investigation if taxpayer is allotted to state? Kaushik ji, that is upheld in many of the cases. Investigations can be undertaken by both states and center. But having said so, my whole point was on the issuance of show cause notice by the jurisdictional officer only, proper officer. Can a jurisdictional officer undertake audit and post-audit issue SCN based on parameters on ADT 02? Chances of abuse of power by such officer? No, sir, there is no chance of abuse of power. Please understand. Yes, this is one way of looking at it, but then please also look at the other way of looking at it, that the officer is of the opinion that this particular demand is to be taken from his investigation. He formed that opinion. Show cause notice is an opportunity given to you why that particular demand should not be confirmed. So the chances of abuse of power, if it is presented in this particular manner, that had he not given that opportunity, there was an abuse of power. But since he has given you that opportunity after framing the opinion, the chances of abuse of power is rather negated. So I leave it. This one question, definitely it is being discussed amongst experts. Good point to take up, but yes, I've share the view which is from the other side also. Can investigation and show cause notice, there has to be some time. See, between investigation and show cause notice, there has to be some reasonable time. And one more most important view which I have, the investigating officer. So suppose investigation was in 2020, a statement was recorded, records were taken on file. Officer who undertook the investigation, he was transferred. And on 2024, there was one officer who came sprangingly on the file because there was a last date to issue the show cause notice without even I'll not say the undertaking the entire investigation, at least giving one opportunity to understand the various aspects of investigation. He simply issues the show cause. This is where I would say that the officer who was forming the opinion is not the officer who investigated, and therefore the opinion framed by that particular officer is not correct. So this is how I would like to address your differential time frame between investigation and show cause. When investigation conducted by DGI, who is the proper officer to issue SCN? See, Manishi, I have presented my view, but the matter is sub judice. The officer who can issue the show cause is the proper officer and not DGI. But this is something which is, I would say, right now sub judice. Do raise the preliminary objection on jurisdiction. But please do not merely keep it to that. You have to address show cause on other aspects also, as we have spoken. Charging section, framing of charge, that has been replied. Gauravji has replied to that query in between. In case a section 70 summon, are the officers bound to disclose the name of the bogus firm? They are supposed to inform you under which inquiry are they issuing this summon. If they are not naming, you can put a letter to them asking under what inquiry, under whose investigation are the summons being issued. So this current Chaudhary Saab has repeated the question, so I'm leaving this. In some case, the officer determine the text and just write a line, applicable interest, a penalty to be paid. No, sir. Penalty under what section? Interest, yes, cannot be computed till the date of payment. So it is an ongoing exercise, but penalty is a fixed amount. Under what section? What amount of penalty is to be levied? Show cause must state that. If show cause fails to state the amount and the section, it is not a valid penalty. So for that matter, tax amount, if it leaves, though it can be deduced from the details given in the show cause notice, no, sir. It has to be given. A zero penalty in DRC summary means no penalty. For remand back cases to the adjudicating authority, whether time limit 73 would be applicable. Now, sir, who has remanded back? If you have gone into a writ under 226, extraordinary power of the Honorable High Courts, yes, they have the time because they are under a direction, and in such cases, usually High Courts give them a time limit in another 1 month, in another 3 weeks. If it is not under the extraordinary, writ petition powers, then in that particular case, no, it cannot be, because remand back can only be done by tribunal or higher forums. Under law, a new show cause notice or show cause notice cannot be amended at any stage after once it is issued. So please understand, show cause notice is not something which is a matter of choice. Once issued, once the charges are framed, the show cause notice cannot be amended at any stage of the proceedings. Right, sir? It is the writing on the wall, it cannot be changed. In case of someone under 70 to produce the information record, is officer bound to state the name of bogus? I think this is what I've already. It should also be signed by officer. In many of the cases, notice is not issued without authorization. I think without signature is what we are saying. Unsigned notices are non-est. This is a trite law. Any notice which is issued without signature, it is any document which is unsigned, even if it is uploaded, are non-est orders. And it is fairly settled position of law. And you can refer to a number of decisions, Rails Engineers, Marg ERP Limited, Ramani Suchit. I think you just look at it, you have those particular cases on unsigned show cause notices or orders. So if it is an unsigned show cause notice, it is non-est. SCN is issued over mail only and not uploaded on portal. In fact, so please, Vijayji, if it is not uploaded, please request the officer to refer to instruction number 4 by 2023 and by the application of Ratan Melting, Honorable Supreme Court circulars instructions are binding on the officer, not on the courts or SSC, but on the officer, they are binding. Can SCN under 74 be converted to 73 even when time under 73 expired? Aditi ji, never. 74 SCN can never be converted into 73. Yes, if the limitation fails, so issuance under 74, if it is there and the limitation fails, in those particular cases, the time frame under 73 still upholds. So that is one exception in 74 which has been provided. Yes, sir. Next one. So uploading, I think I have clarified enough. Can proper officer issue DRC 01 under 74 before DRC 01A? I think it is the vice versa. 1A has to be before DRC 01. Tarun ji, I think I'm correct, sir. इतने
एकदम
सारे
correct.
one और 1As हो गए हैं हमारी लाइफ. Even I think DRC 2, no, sorry, DRC 1B, DRC 1C, a lot of DRCs, different mechanisms are formulated by the department. Officers raises the fact that non-filing of 3B violates 16(2)(c). However, the tax can be paid through other means also. Sir, that is what I'm saying. Sukrit ji, very, very valid a point. I would add to what Sukrit ji says. Now, this is the view, or this is how I would say now we are talking. Where is the basis of the officer alleging non-payment by the supplier? Mere statement in the show cause notice will not make a valid allegation. Allegation should be supported by relied upon documents or information which is available to the taxpayer by any means. So if it is not available to you that your supplier has paid the taxes or not, it cannot be presumed from the show cause notice. Please do remember that. And yes, you can use your point very strongly. Sukriji, thank you for adding this. DGGI cannot adjudicate DRCs. On what basis it can take up to decide 1A? Kaushikji, again, I would congratulate you. This is also one of the very good points to be taken up. If you don't have the authority to adjudicate 1A, how can there be two proper officers for 1A and 1? So there has to be one proper officer who decides. If you are taking a decision on 1A, then you are an officer who can adjudicate also. I completely subscribe to your view. Very, very reasonable a point to challenge the jurisdiction. Can they name SCN as demand come SCN and use harsh words to pay? Aditi, don't go by words. Please, they may say demand note SCN before recovery. The fact of the matter is it still remains a SCN under 73 and 74. And if they very light word, if they use SCN, humble SCN. Will it make it humble? No. Don't go on the titles, ma'am. Go on the spirit, the power for them to issue SCN. How should face someone issued under 70 by anti-evasion department? Sir, you don't have to go with the approach. I am telling you again, the someone speaks all. You should be very clear what is the agenda you are going to address. So if they're calling for documents, take those particular documents. If you're going for statement, yes, there can be surprises. If you are not aware or you don't remember a particular thing at that particular point, you can simply state that I am right now not very clear or I don't remember this particular piece, but I undertake to submit this information within a particular period of time. And that should be a very reasonable time, depending on the quantum or factum of the information. What is the difference between ASMT 10 and DRC 01A? Sir, ASMT 10 is basically the form in which the inquiry in respect of a discrepancy under section 61, read with rule 99, is being undertaken by the department. While DRC 01A under 142A, the form is a pre-intimation for issuance of a show cause notice. Why is it being given? There is a lesser penalty if you pay before issuance of a show cause notice. And that is the whole relevance of DRC 1A, because opportunity is given to every taxpayer that he can pay before issuance of show cause notice and avoid penalty. Are they bound to tell the name of the firm under? I think I've given it. Higher IGST liability intimated by GST officer populated from variable sites, but our calculation coming lower. How to challenge this demand under appeal? At the outset, is the show cause issued? If show cause is issued, then the particular e-way bills should be mentioned. If those particular e-way bills are mentioned, then in those particular cases, I think you have already replied that why those particular e-way bills will not culminate. So maybe you are giving some, you are a work contractor supplying goods under delivery challan. So you have raised a separate invoice for that. So those particular e-way bills cannot culminate into a demand. So I hope those particular e-way bill wise replies have been given by you, and therefore at the appeal stage you cannot produce additional evidence like that. You have to take the permission of the commissioner, but yes, he can include those additional. And usually, if the case is reasonable, there is no harm in accepting additional evidences. But please, my dear friends, as I told you earlier also, the investigation and the show cause are the stages where you should be very careful in terms of assimilating, preparing, presenting the details. Neither unnecessary details should form part, nor necessary details should be left out. That is the rule which you should keep in mind while addressing the show cause notice. Whether multiple show cause notice can be issued by for a single year, yes, sir. However, two things. Number one, it should not result in a change of opinion. So, audit was conducted in 2022. One show cause was issued in 2023. Another issued in 2024 for 17-18. Now, the one which is issued in 2024, you have a very strong ground to say that there is a change of opinion, because timeline for 73 was already lapsed. Now they came out with 74. So there is a clear, I would say it's prima facie that there is a change of opinion in this particular case. Whether multiple show cause notice, I have already addressed, but yes, within the reasonable timeline, on multiple issued, single issue, single show cause. If second show cause, it is void, you can simply say already show cause notice so and so has been issued on this point and of this amount. You are requested to kindly withdraw the second subsequent show cause notice because it is void on the same issue cannot be issued. Can adjudicating authority revise his own SCN? Is there a power under the statute? No. They can withdraw with the observation that there is some discrepancy. There cannot be, even in my humble opinion, a corrigendum to a show cause notice. Apart from very minor glitches, but yes, amounts were wrongly considered. Interest penalties left. No, sir. Likewise, for the SSC, same rule applies. SSC की क्या गलती थी? उसकी भी तो कुछ गलतियां ही थी जिसके लिए शो कॉज इशू। अब शो कॉज में गलती है तो वो कैसे गलती वैलिड हो जाएगी? Sorry, I spoke in Hindi for after such a long time, so I think this much is allowable. In 3B filing during period 17, ITC availed section credit note reversal is shown. Department is demanding to pay all credit note reversal. Is it valid? See, again, I'm saying what we are going is with the mindset that inquiry culminates into demand. What I'm saying is show cause. What are the allegations in show cause? If you have discharged your burden of proving that the credit note reversals are on these particular valid grounds, supporting documents have been produced. Department has to allege your obligation has been completed. How is the common time limit of 42 months beneficial to assessee? I think let's not go, Siddharji, into the technical policy issues. How is it useful? How is it not useful? Let's leave it for the moment. Whiteboard, एक बार देखें sir. Sorry. SCN issued for multiple period can evoke parawise section 34, 33. Yes, sir. I think yes. They can. Can the officer increase the demand in DRC 01 compared to no, sir? They cannot, because that pre-intimation has its own sanctity. But yes, if it is something which is only apparent mistake, then courts might take a different view. But if it is grossly different ground, I think it will come in your favor. Interest is being discharged for late payment. Immediate discretion, earlier in Delhi High Court. the pre-consultation has been taken as a very important part of raising a demand. Interest is being charged for late payment of tax paid during 1718 to 1920 through SCN as demand of interest related to those period valid via SCN. Yes, I think Aditi ji, maybe I'm not able to get your question, but for interest, SCN has to be issued. Do they have the authority to issue one SCN for 2 different financial years? Yes, sir. They have. I have been told that that facility is there, and you know, there is nothing in law which bars that kind of issuance. So I don't see that maybe being too much particular about 2 years may not be a very good ground to be taken up. If an order has been passed and appeal has been filed against the order, can the same officer issue the SCN for same financial year? I don't know. But if order has been passed and appeal is filed, can on the same point SCN can be issued? No, it cannot be. Once a matter has achieved a finality, it cannot go into a show cause notice mode. Right, sir. I think with this, I have replied to almost all queries. I might have missed my humble apologies if I missed on some point. I'm always open and will take it up on some other point of time. Tarunji.
Thank you so much, sir. It was a wonderful deliberation, and I personally think, sir, whenever it's a physical seminar, it's a webinar, you make the audience very interactive, and it's a very wonderful thing that you have put an enlightenment on the section 61, 65, 67, and different telling about their 16 sections where the different show cause notice can be issued and the 4 C's of the show cause notice, as well as your case laws, Divya agencies and all. Thank you so much, sir, for your wonderful deliberation.
Much of the content was copyrighted, so let it. Thank you.
Yes,
Thank you
sir.
for being so
And
attentive.
yes, sir, and out of the 100 audience, if 35 questions are there, I think it was really an interactive and insightful session for all of us. Thank you so much for everyone.
Thank you to everyone.
Thank you so much, sir. Thank you. Thank you.
Thank you, Gaurav ji, for the wonderful session. I think अब आपका e-memento उस time पे I want to share it once again क्योंकि उस time पे ठीक से show नहीं हुआ था.
Thank you, sir.
I have already WhatsApped this to you. So if you can take a print and keep it in a library, it will be honor of pride for us.
No, I'll definitely do it, sir.
Thank you so much. So to all the participants, we really apologize that because of some technical issues in Zoom, the participation was restricted to 100, but we are trying, and maybe if it is not resolved, then maybe for tomorrow onwards, we will create a separate link and circulate in the group and through email. And this recording we will share so that the people who have missed can see this recording. So with this, I will take leave now and we'll close this session. Thank you, Gaurav ji, once again. And we will meet again tomorrow at 5 o'clock. Thank you so much. Thank you. Thank you.
Thank you. Thank you.
Thank you.